Uh,
And
all
hello,
right, we'll see.
and hello.
Sorry about that.
That's okay. Hello, everyone, and welcome back to our podcast. And today I am honored to have on the former governor of the state of Alabama, Don Siegelman. Don is currently a practicing attorney working through Advocates for Justice, a nonprofit with people and organizations that strive for criminal justice reform. He is also a black belt in karate, does volunteer work for people with Parkinson's, and recently organized to pay off medical debt owed by thousands of people in Alabama's poorest regions. Also, Governor Siegelman is the only person in Alabama history to be elected to the four highest offices in the state's history. Governor Siegelman, welcome.
Thank you. I enjoyed every moment of my life in public service. And I was telling someone recently that I calculated I was on a statewide ballot about 19 times for the Democratic primary, runoff, and general election. And I won all of those races except for two. So I enjoyed my run in Alabama politics, and I love the people of Alabama, and it was my pleasure, um, really, to I focused, of course, on education and initially on a state lottery to pay for early learning and childcare for working families and for free college education like they do in Georgia. But after that vote was defeated in 1999, I focused on bringing in higher paying jobs, brought in Honda, Toyota, Mercedes, Hyundai, expanded Lockheed Martin and Boeing, and uh, rebuilt the state docks in Mobile. Anyway, we had a lot of fun doing what we did. So I want to thank the people of Alabama and the people of North Alabama, Jackson County especially, for supporting me all those years.
That is correct. Sir, your big focus in your life now is on criminal justice reform and really particularly the death penalty. You and former Governor Bentley wrote an op-ed in the Washington Post talking about your regrets for presiding over executions while you were governor of Alabama, and some of the regrets you had. Could you talk about some of those cases and if you knew then what you know now, what you may have done differently?
Well, yeah, I would, what I know now through personal experience. When I was campaigning for a state lottery to pay for free college education and early learning and childcare. I was trying to raise money for the ballot initiative that was put to a vote by the people of Alabama, the one I referred to earlier that was defeated. But I was charged with bribery, not because I had benefited by a single penny, but because I reappointed someone to a state board, a non-paying state board, on which he had served for 12 years, appointed by three previous governors. Anyway, my point is, I was convicted of bribery for something that never happened, that was only made up in the minds of the prosecutors, and it dawned on me at that moment that people who had come to me as governor for clemency, but who subsequently were executed, that those men faced the same justice system that had just convicted me of something that never happened. So I really got into studying about Alabama's death penalty process. And in the course of that, I found out that prosecutors get 99% of the indictments they want. And that's a pretty high percentage. I mean, yeah, if you can get 99% of anything right, you're up in the top 1%, obviously. So, how did they do this? Well, I found out that in 1976, this is to remember. 1976. I'm going to mention it two other times. The Supreme Court gave prosecutors absolute immunity from civil liability. You can't sue a prosecutor, even if they knowingly and willfully present false evidence, false testimony, or withhold what's called exculpatory evidence, evidence that would tend to convince a jury that you were innocent. They can withhold exculpatory evidence and present false evidence to get an indictment or a conviction, and you can't sue them. Now, to show you, that was 1976. We've been rocking along with this for quite a while. In comes President Obama. One of the first cases brought before his court in January the 4th, 2010, was a case where two black teenagers had been framed for a murder they didn't commit. It turns out that the investigators went down a trail that led them to a white suspect, a friend of the police department's. So they found a young black felon and swapped out a light sentence for him if he would help convict these two teenagers of this murder. 25 years later, after they served in prison, they were suing the investigators and the prosecutors who presented false evidence and withheld exculpatory evidence. And President Obama's lawyer, then the Solicitor General, Elena Kagan, argued before the U.S. Supreme Court, and I quote, U.S. citizens do not have a constitutional right not to be framed. Let me repeat that. She's arguing that U.S. citizens do not have a constitutional right not to be framed. And the sad part about that, one, she didn't have to argue that, but the other sad part is that it is, in fact, the law. It was the law in 1976 when the Supreme Court ruled that way in the Imbler case, and it was that way when President Obama was in office in 2010, and it is still the law today. You cannot sue prosecutors, even if they lie, to frame someone. So that was 1976. The Brennan Center for Justice did a study showing that in 1976, mass incarceration hovered around 250,000 for decades. After the Supreme Court decision in 1976, giving prosecutors the ability to present false evidence and false testimony and not be sued for it, mass incarceration shot up to 1.3 million and then up to over 2 million. The third tie into 1976, the Death Penalty Information Center in Atlanta did a study that showed that for every 8.3 people, basically every 8 people who have been executed in the United States since 1976, one person has been exonerated, which statistically means that we were getting it wrong about 12% of the time. Of those people who were exonerated, 70% was based on prosecutorial or police misconduct, meaning that they had used false evidence, false testimony, or withheld exculpatory evidence, authorized by the Supreme Court decision in 1976. Of those people exonerated because of misconduct, nearly 80% were African American, were blacks, which means that prosecutors have been targeting black people for murders they didn't commit and framing them to get a conviction. Back to Alabama. Go ahead, sir.
That is scary.
Well, it gets worse. So Alabama has about 156 people. It's hard to keep track, give or take, on death row at this moment. Uh, Arguably, about 134 of those would not be, 134 of the 156 arguably wouldn't be on death row in any other state. And let me explain why. In 2020, Justice Gorsuch, a Trump appointed judge, the Supreme Court ruled in a case, Ramos versus Louisiana, that it takes a unanimous jury to convict someone of something that warrants death, a serious crime that warrants death. And then the Supreme Court, in Gorsuch's opinion, they link that a non-unanimous jury to a Jim Crow law. Excuse me. So the United States Supreme Court, in the Trump court, goes back to 1870 and finds out that before that, white folks were perfectly happy with unanimous juries. But after the Civil War, when black folks could be put on juries, could serve as jurors, they realized that one single black juror could prevent them from carrying out an execution. So they changed it to non-unanimous juries. Every state in the United States, other than Alabama, did the practice of non-unanimous juries making a decision to warrant death. So Alabama has about 108 people on death row based on non-unanimous juries. So let's take those and put those 108 aside. Alabama in 2016, the U.S. Supreme Court ruled that only juries, not judges, but only juries could decide the facts warranting death. In 2017, Alabama abandoned its practice of allowing judges to override a jury and order death, even though the jury had voted for life. So Alabama has currently, at the time, they had about 31 people on death row in 2017, based on judicial override. But today we have about 25 people on death row based on judicial override. Again, judicial overrides were declared unconstitutional by the United States Supreme Court in 2017. In 2016, in 2017, the Republican legislature and our Republican governor, Kay Ivey, passed and she signed into law a ban making judicial overrides unlawful in the state. So today we still have 25 people on death row based on this unconstitutional and now unlawful practice in the state of Alabama. The only difference today versus when they were sentenced is timing. If they were sentenced today, they'd all be serving life without the possibility of parole. But today, because the law was not made retroactive, we have 25 people set to be executed. One, it was just announced today, Jeffrey Lee, who was sentenced by was a judicial override case, as I understand it. So that's kind of where we stand. And so Governor Bentley and I looked at, he looked at his record, I looked at mine, and we both agreed that if we had known when we were governor what we know now, we would have commuted the sentences, granted clemency to a lot of people who are on death row because they don't deserve to be there.
We very rarely see that in Alabama. I will give Kay Ivey some credit. She has commuted two sentences in her term, including one in Alabama this year, uh, which I will commend her, but I will also say she let it get a lot closer than it should have been to the time for clemency. Governor, one of the cases that you, Governor Bentley, and some former Chief Justices of the Alabama State Supreme Court and former district attorneys have been calling for a new trial in is the case of Tafaris Johnson. Can you tell us about Tafaris's case?
Yeah, in a nutshell, um, he wasn't associated with the victim. He didn't know the victim. The victim didn't know him. He wasn't at the place where the victim was murdered. There are a number of witnesses that testified that um, he wasn't there. He was somewhere else. The only evidence that tied him to the murder was the testimony of a single witness who 17 years later, after the trial, it was discovered that the government had paid the witness $5,000 for her testimony, gave her a reward. Um, if the jury had heard that the government was paying the witness to testify, the likelihood is Forrest Johnson would not have been convicted. So I've joined with Bill Baxley and Danny Carr, the district attorney, with Governor Bentley and a number of former justices of the Alabama Supreme Court, uh, asking the current judge, who is uh, seated to hear this case, to grant to Forrest Johnson a new trial. You know, you can't undo death. We have each of us has an opportunity. In this case, the circuit judge who's considering this, it's not going to hurt her. Uh, Certainly not going to hurt her politically because we've got Republicans and Democrats both calling for a new trial. So why not just go ahead and rule, I'm going to give this guy a new trial and we'll let the chips fall as they may. If the jury convicts him again, he's going to face an execution date. If they don't convict him, he's free. Or if they convict him of something else, but you can't undo death. And some of us have come to the conclusion that this might be something that God should do and not humans. You know, um, Shakespeare said something like this. I can't remember the exact words, but and not that his voice counts for anything, but it was so eloquently said. He said, "Mercy falls like rain; it blesses twice. It blesses those who give mercy, and it blesses those who receive it." So, you know, the judge and Governor Ivey both have a chance uh, to show mercy and to receive a blessing, uh, I think, from God for doing that.
You know, I'm I'm not a religious person, but I believe that, life in prison is a much more harsh sentence than
Oh, absolutely.
the death, than execution. And, my personal belief, this is a question we'll get into later, is a violation of the Eighth Amendment. So that's where I come at it from. Sir, one of the things in Alabama that gets a lot of coverage is Alabama's parole system. And it has a lot of problems. But you were instrumental in getting one man out. Tell us about the case of Robert George and the case of Mr. William Patrick Smith, who was accused of stealing $2.
Yeah, be happy to. Well, they're dramatically different cases. Robert George, well, both of these men are black. Uh, Robert George was at a family reunion, and they were all, people were drinking at the family reunion, and he had got too much to drink, and somehow a gun got involved, and it went off, and he accidentally killed one of his relatives. He pled guilty to life in prison, and I got involved. I guess it was 2017, maybe 2018. I can't remember, but and we initially filed a Rule 32, which only because he had filed one before, anyways, more legal information than you probably care to know. But anyway, it had to if the DA opposed it, then it was out. So I lobbied the DA and the judge, and it didn't work. The DA was opposed to it. So we filed. Uh, this man was 87 years old. He had been in prison for, gosh, I think since 1993, and he'd been there for about 35 years. And you talk about, when you take 35 years of somebody's life, that's a pretty serious chunk of someone's life. Well, he had missed his children and grandchildren and great grandchildren. Um, he had a lot of medical issues, so we were able to, even though he had been denied parole over and over again, we were able to get two of the three votes for his release. He was released. He was released in April a couple of years ago, and then died in July. He was released in April, died in July. But so he had, a few months to see his children and grandchildren before he passed away. But the fact that he was so old and had been denied parole over and over and over again, and he was, absolutely harmless. Of course, he was remorseful. He didn't intend to hurt anybody. It was an accident. That was Robert George. The story of William Patrick Smith. I was trying to nurture my brother back to health last year, and I found a lady who would clean his, vacuum his rugs and keep his place a little neater. And she started telling me the story of her brother who had been in prison for over 20 years. And I corresponded with him, and he sent me some of the legal documents. I gathered the report, the initial report of the police, and everything he said turned out to be true. He was homeless in Birmingham on University Boulevard and at a gas station convenience store. And he thought he was helping a lady check out. I'm not sure why he thought he was, or why she needed his help, but he was showing her that he didn't have any money. He emptied his pockets and he didn't have any money. All he had was a small 3-inch pocket knife. Well, she interpreted that as a threat and gave him $2. She told the clerk that, that she had been intimidated to give the man $2, and he was arrested on a first-degree armed robbery charge. His judge, because he had a couple of, I'm gonna call these piddly felonies, nothing involving any violence whatsoever. It was his third felony. So under Alabama law, three strikes and you're out. You get, a life, get a life sentence, basically 25 years to life. The judge told him if he didn't plead to life, he was going to give him life without parole. William Patrick Smith, before he even went into prison, got baptized, went through all of the faith-based training that he could, went through every correctional program that was offered, and for the last 11 years has been on work release, meaning he worked for 8 hours during the day, then reported back to his cell, where they locked him up at night, and would go back to work the next day. He had all kinds of glowing recommendations from correctional officers, wardens, people he had worked for, but still had been turned down for parole over and over again. So um, anyway, long and short, I called Sue Bell Cobb and got one of her lawyers assigned to work with me. A wonderful, bright law student from the University of Alabama, and we wrote what's again a Rule 32. I went down to see Danny Carr, the DA, and he agreed that the man should get time served and get out of there. That shouldn't have been serving life in the first place. But the Judge May, agreed and ordered him released on time served. But here's a guy, a homeless man, who meant no harm, did no harm, never did anything physical to anybody, was sentenced to life in prison, stayed there for 20 years. And, it dramatizes both now the parole system has changed. I was going to say dramatizes Alabama's prison parole system, but also our sentencing structure, which is, we over sentence people, which costs taxpayers money. And, a man like this could have been rehabilitated in 2 or 3 years and been out working as he did and as he's doing now. Um, Same with Robert George. He never intended to hurt anybody. Uh, so we need to, fortunately, and again, to Kay Ivy's credit, she appointed a new person to the Pardons and Parole Board, and they are now making a difference, and are letting people out who should not be in prison any longer.
Yes, that new member is actually from Jackson County. He was the former chief correctional officer here in the county. So a little bit of a personal local connection to me. And one of the
Well, good. Congratulations, and I want to give him thanks for his taking the time to look at these cases and make the right choices.
one of the things that I was reading about when the previous head of the pardon board was on there was that the Alabama Appleseed Foundation reported that a lot of these people that were being denied parole, like you said, would go out and work 8 hours a day and then be locked up again at night, and they were denied parole, and they were going to work for private companies, like McDonald's or other, private companies in the community. But this member of the parole board said they're safe enough to do that, but we can't let them out. So,
Yeah,
uh,
it just sometimes uh, those in power want to appear tough on crime so that they can garner more support from their political party or their friends or neighbors or voters. If I can go back to judicial overrides for a minute, of the people on death row based on judicial overrides, assuming they're 25, 17 of the 25 are black men. All of them were sentenced by a white judge except one. The Equal Justice Initiative did a study showing that judicial overrides in a non election year were around 7%. The next year, when judges, those same judges, when they ran for election, judicial overrides jumped to over 30%. So, um, that really is telling to me. I mean, it appears that, whoops, did I lose you? No, I
No,
didn't lose you.
you're good.
Um, so judicial overrides of these 17 blocks, all of them were sentenced by a white judge except for one, and all of the judges, all of the 17, were running for reelection or election at the time they did judicial overrides. You
That
know, you can take that for what it looks like to me that somebody was trying to be tough on crime.
Yes, and I think that is also one of the drawbacks you could have from an elected judiciary. That, you have these judges who have the fear of not appearing tough on crime, and, here's the perfect opportunity, so to speak, to show how tough they are. One of the states that has really ramped up executions recently is Florida. Florida has seen a rapid acceleration of executions in the past 2 years, particularly. Um, Maybe talk about some of the injustices we see in the Florida death penalty and why it's so troubling that executions are on the increase there.
Well, it's interesting. Yeah, I had written an editorial for the Sentinel, I think it was in Florida, about this subject. It's, it's troubling because for two reasons. In 2020, when the Supreme Court ruled that non non unanimous juries were linked to Jim Crow and said that you had to have a unanimous verdict in order to convict someone of a crime warranting death. Florida, as well as all states other than Alabama, abandoned that practice of sentencing people by non unanimous jury recommendations. When DeSantis was running against Donald Trump, he had the law changed to allow an 8-4 verdict for death to be carried out. So he has now done a flip flop on the death penalty and is allowing people to be sentenced to death based on non-unanimous jury decisions. Alabama has a 10-2 non-unanimous jury ratio. I still believe it's unconstitutional based on that 2020 decision of the Supreme Court, but that remains to be straightened out at some later time by the United States Supreme Court. But the second thing about Florida that bothers me is that Governor DeSantis is the sole person who chooses who is going to be executed. So he can pick and choose from whomever is on death row as to whether or not they're going to come up for execution. And as you know, just the other day, it may have been yesterday, they executed two people on the same day.
Um, One of the frightening statistics that I looked at is since the reintroduction of the death penalty in the United States after the Gregg decision 50 years ago, Ron DeSantis has executed 28% of all people in the state of Florida since the reintroduction of the death penalty. But here's the part that is really troubling. Over half of those executions have occurred since 2025. It's just a massive, massive increase. And one has to think, why is he wanting to do this when he will be out of office in January of, as we're recording this, less than 6 months from now. Um, but back to him being the sole decider, that was something that I blew my mind. I was listening to a New York Times podcast about the spiritual advisor to these inmates on death row in Florida, and it talked about how that one of the families of a death row, a victim, sent him a Sharpie and he used that to sign the death warrant. I mean, he's using it for theatrical purposes. And that to me is just something that shouldn't be, tolerated by voters. Um,
Well, I certainly agree.
how does it work in Alabama with setting execution dates and the process of getting, a death warrant to go active?
Well, the way it did work when I was governor was that the attorney general requested an execution date. Um, the governor today I think, plays a stronger role in that process. Um, not exactly sure. Um, I want to say that it's still rests with the attorney general to request an execution date. In other words, someone gets convicted of capital murder in Connecticut County, the attorney general, and once that person has been incarcerated uh, and is on death row, then the attorney general can request an execution date. I don't know, honestly, do not know whether the governor uh, can move someone like DeSantis can pull anybody out of line and take somebody from the back of the line and move them to the front.
He
I I
can.
I don't. What's that?
He can.
Yeah, and I'm not sure what the situation is in Alabama. The I guess that even if Governor Ivey does not play an official role, that if she were or her legal advisor called the attorney general and said, I want you to send the name of so and so, I'm sure that would probably be met with the attorney general's approval.
Yes,
Since he's never met an execution that didn't satisfy him. So yeah,
Steve Marshall, even in the cases where Kay Ivey intervened, vehemently opposed her, commutations in those cases. Steve Marshall, like you said, is a very firm supporter.
it, well, it's not only that. I mean, it goes well beyond that. It's just like he's they used to use the term bloodthirsty, and let's take Rocky Myers. One of the we both compliment Governor Ivey for granting clemency to Rocky Myers. Rocky Myers is another case, a judicial override case, but Rocky Myers was not. There was no physical evidence to tie him to the scene of the murder. In fact, the victim knew Rocky Myers. The but when the victim was alive before she died, they asked her to identify who was trying to kill her. She could have said Rocky Myers. I know Rocky Myers. I mean, she knew him. She didn't identify him. She identified a large black man. Well, you know, the other part about Rocky Myers was His jury was 9-3 in favor of life without parole. Again, he wasn't associated with physically associated with the scene of the crime, and arguably he had a mental deficiency. He had failed a IQ test several times. So um, anyway, there's kudos to Governor Ivey for granting Rocky Myers a reprieve and getting him off death row. But it's again another case where Steve Marshall criticized the governor for doing so.
And of course, in the Sonny Burton, oh, oh, Governor, before we had our technical hiccup, you were talking about the case of Rocky Myers and the Attorney General's opposition to the governor granting him clemency in that situation.
Yeah, it was. It was there was every reason to grant clemency to Rocky Myers. It was a judicial override case. He wasn't at the scene. The victim knew him but did not identify him when asked by the police, who was it that was trying to kill you? So there was all kinds of reasons for KIV to grant clemency. In the case of Sonny Burton, KIV again did the right thing. This was a non-unanimous jury recommendation for death, but um, Sonny Burton wasn't the person who killed the victim. There were two people. He was one. But he wasn't even in the building. They had a videotape showing who killed the clerk, and it wasn't Sonny Burton. So one would argue, why was he ever convicted in the first place? But when KIV did the right thing and granted a reprieve and granted him clemency, the first words out of Steve Marshall's mouth was, something running KIV down for granting him clemency.
Yes, I won't get too political on here, but I think that had to do with how close that was to the primary election that Steve Marshall was running in at the time, is why he was so adamantly opposed to Governor Ivey granting clemency in that case. Another case you have worked on is the case of Kenneth Eugene Smith. Why don't you tell us about Mr. Smith?
Well, Kenneth Eugene Smith was a judicial override as well. Uh, he was he was in the house where the murder took place, but he was not the person who killed the victim. He was rummaging around trying to steal something to support a drug habit. He was young, I think 23 years old at the time, and had served, gosh, I don't know how many years, 35 years on death row. Um, and his jury voted 11-1 for life in prison without the possibility of parole. And, when a jury listens to all of the evidence and hears everything that has to be said, and juries return what they consider is uh, a just punishment, the Sixth Amendment gives juries that right. We have the right to trial by jury, not by judges. And the Supreme Court in 2016 agreed and said that only juries, not judges, can make the decisions about the facts warranting death.
That is very, very true. Another thing that really people I think need to be aware of is Alabama's execution method, as it has become harder for states to acquire the drugs that they previously used for lethal injection. And as appeals have dragged on, the drugs they use because they're medications have expired. So Alabama has turned to a different form of execution, which is basically a suffocation of the individual. Can you talk to us about how this is a violation of the Eighth Amendment, and what is the status of cases of prisoners making that argument?
Well, we don't know what the status is, honestly. With regard to Jeffrey Lee, he was arguing that death by suffocation, they call it nitrogen hypoxia, but it's basically they're taking the oxygen out of your lungs and you suffocate to death. And after the judge looked at all the evidence and heard the testimony from witnesses about the length of time a person suffers when they are suffocating to death, she decided, and rightfully so, that that was cruel and unusual punishment, and death by nitrogen hypoxia should not go forward. The legal status of that is still in limbo, so to speak. We do know, because we have testimony, we have evidence, and we have witnesses who have watched people, struggle for minutes before they die. You know, I don't know whether anybody has ever experienced a situation where they've lost the ability to breathe, but I remember, a couple of times when I was younger, having to struggle to breathe, and it is a very, very frightening and uncomfortable situation to find yourself in. But psychologically, painful, and one is desperate for breath. So she ruled that it was unconstitutional based on the Eighth Amendment, and you know we're now turning to back to lethal injection, which we have also had trouble with. Kenneth Eugene Smith, they tried to kill him through lethal injection, but couldn't do it. So then they opted for nitrogen hypoxia, suffocating to death, and they did that. There have been other inmates. Another Smith, Alan, I think it's Alan Eugene Smith. He struggled, before dying. We've had other inmates where the prison guards and others who are trying to inject the needle could not find a vein, and it's so. We get back to this situation where the state is trying to kill people through various means, and the firing squad has recently come up as an alternative. But no matter what method you choose, it raises the question of, going back to something you said, isn't taking someone's entire life and taking them away from their family and putting them into this hellish situation of prisons in Alabama, isn't that punishment enough? And besides that, people in prison are getting murdered right and left. And the other part of this is the spiritual, moral part, which I happen to fall into, and that is, I think that I don't know that God is necessarily going to look down kindly upon us who decide to take matters in our own hands. To me, it's this. Taking someone's life it ought to be reserved for for God and not for man.
Governor, you talked about Alabama prisons briefly. Um, the documentary, The Alabama Solution, was nominated for an Academy Award and really showed the horrible conditions on the inside of Alabama prisons. And it was because Alabama prisons are so rife with, contraband that these inmates were able to get cell phones into the prisons and show the reality inside prisons. Have things gotten better in Alabama prisons since sunlight has been shown onto the reality, or are they still as awful as the Alabama solution depicts it to be?
You know, I guess two things. One, I don't know the answer to that question. I do know that uh, Andrew Jarecki, the producer of that documentary, was kind enough to list me as one of the first, if not the first, credit for cooperating with him on his adventure here in Alabama. But I do not know. But I would have to guess that things have not improved because it's going to take a massive overhaul of our prison system to produce the kind of results. We don't. This is not a matter of retribution or revenge or warehousing. It's the Department of Corrections should be about that, about correcting behavior and working to find solutions so that people can get back to an ordinary and productive life. And I think that, of course, starts with, dealing with alcohol and drug abuse, because about 85% of the crime is related to that. And then mental health is right up there, that you've got to deal with the mental health issues. And sometimes that can be solved through some kind of mild medication. And then the other thing is that most people who enter prison because they don't have job skills. And most people who leave Alabama prisons still don't have job skills because we don't teach education and job training in our prison system the way we should. So, we need to solve the problem of mass incarceration. We've got to get rid of this 1976 decision that allows prosecutors to do anything they want, present whatever evidence they want or don't want, to get the kind of outcome in a grand jury that they want or don't want to see come out, or they want to see come out. So 95%, they get 99% of the indictments they want. The Washington Post did a study that showed that when it comes to holding police accountable for killing black folks, that 99% drops below 2%. So prosecutors don't actively seek the indictment of police for killing black folks. And that's what it comes down to. They did this study after George Floyd was murdered before our very eyes.
That
So we've got to reform. We've got to curtail immunity for prosecutors, reverse that decision in 1976, hold prosecutors accountable so that they cannot present false evidence, false testimony, or withhold exculpatory evidence and get away with it. The second thing we need to do, I think, is to reform the grand jury system, because there is no judge or lawyer in the grand jury, no judge to hold anybody accountable, and no lawyer for the target, the victim, I mean, the target of the prosecutors, to say, hey, wait a minute, you didn't show the video footage of the Sonny Burton, at the convenience store. You're convicting this guy, but we've got video evidence that you didn't present to the grand jury. So, we've got to have some reforms, both legally to hold prosecutors accountable, and then we've got to have some reforms of our grand jury. I'll give you another example. Grand jurors are not even voir dire. Voir dire is a legal term that means that both the prosecution and the defense lawyers get to ask potential jurors questions about whether or not they might be prejudiced for or against the defendant or the state. Grand jurors are not questioned at all. So they all may be friends of the police department, might be related to somebody so our grand jury system is has a number of things wrong with it that needs to be straightened out. And our prison system, as we discussed, we need to shift from retribution and warehousing to dealing with the issues that got them there in the first place: mental health, drug abuse, alcohol abuse, and the lack of job skills. And with that, sir, I'm going to have to say I enjoyed being with you today and enjoyed talking to your avid listeners and those who watch this podcast. So thank you for your call.
Thank you, sir.